a voluntary and unilateral act, and the African courts have already affirmed this in the case of Ngabre and Rwanda, citation duly supplied, Your Excellency. Your Excellency, if a right is optional, or if a duty is optional, it also includes the duty to withdraw, Your Excellency. Your Excellency, what the respondent state has done is simply to withdraw the declaration it has made in the first place. Your Excellency, the Republic of Edera has exercised the internationally recognized sovereign prerogative on 15 August 2025 when it withdrew this declaration, Your Excellency. Your Excellency, the withdrawal was publicly announced and it was effective immediately. Therefore, Your Excellency, the withdrawal is valid according to the court precedent in this case, and it is lawful according to the context of this case, Your Excellency. Your Excellency, on the second aid of submission, counsel for the respondent submits that the withdrawal does not violate the African Charter or any other human rights instruments. Your Excellency, the applicant has argued that the withdrawal weakens human rights protection. Respectfully, Your Excellency, please.
Counsel, I think I'm a bit confused here. Are you arguing the substantive issues, or you are discussing the issue of admissibility and jurisdiction? I mean, I'm at sea. I can't follow through your argument. I asked you at the beginning of your statement, you are supposed to tell us, argue on jurisdiction, whether this court has jurisdiction. Tell us about the issue of admissibility before you go to the substantive issue. But I'm at sea. I don't know what you're doing. Well, can you please try to bring me up to speed? What exactly you are trying to do?
Much obliged, Your Excellency. In order to save time, Your Excellency, counsel for the respondents has merged the issue of jurisdiction and the first substantive issues in this case together, and we are addressing both the issue of jurisdiction and the first substantive issue together, Your Excellency.
There's no. If you do that, we will not be able to follow.
That's not.
Is that where
that's not the practice,
sir?
Yes, I'm trying to tell counsel that that's not the practice. You need to first identify if this court has jurisdiction first. Before we go
Yes. Let us know.
They're not flowing with you. So please address jurisdiction first and admissibility.
Then you can then have a substantive issue. Is that's the way it should go. Discuss the issue of jurisdiction, address the issue of admissibility. But however, it's your argument. If you feel that you weren't prepared for that, you can just go on in the way you are prepared. But the practice has always been you tackle the issue of jurisdiction, admissibility, and then go to the substantive issue. I think that's what is stated in the fact. So you are not supposed to model issues together. You're supposed to tackle them one after the other so that the judges can follow through. So that on jurisdiction, admissibility, and all that. Thank you.
Much obliged, Your Excellency. Your Excellency, on the issue of jurisdiction, the counsel for the respondents respectfully submits that this court lacks the jurisdiction to entertain this particular case, simply because, Your Excellency, the respondent state has the optional sovereign option to actually either make a declaration under the Article 34(6) of the protocols of the African courts, or to withdraw. Your Excellency, according to the facts of the case, in 2017, this respondent states they made this declaration, but August 2025, they withdrew this declaration before these applicants filed this case before this honorable courts. Your Excellency.
Okay, my question to you is very simple. My question to you is very simple. Is only through Article 36(4) that persons have access to this court, or are there other ways through which parties can have access to this court? Because you seem to be, talking about the withdrawal and the withdrawal. Let us understand, is just only Article 36(4), is it by only that status that people can approach this court, or there are other means by which people can approach this court?
Your Excellency, for individuals and NGOs alike, it's only through the Article 34(6) that they can approach these honorable courts. However,
so okay, now if that's the case, in the NGOs with observer status, they have the power to approach this court.
Your Excellency, NGOs with observer status do not have the power to approach this court unless the declaration has already been made by the states, Your Excellency.
What law says so? What rule can you point us to the rule that says so?
What's the authority?
Your Excellency, Article 5, Subsection 3 of the African Charter, Your Excellency, say that individuals and NGOs would only have access to these courts if the state has made a declaration under Article 34, Subsection 6, Your Excellency.
5.3 of what did you say?